Okay.
All right, we are recording.
Okay, thank you, Maddie. It is 1 p.m. on June 30th, 2025. This is a meeting of the Land Use Review Board. I am Janet Hurley. Sarah Had will not be able to join us today, and I will ask the remaining 3 members to introduce themselves. Kirsten.
Kirsten Sultan, board member present.
Alex.
Alex Weinhagen, board member. Nice to see you all.
And Brooke.
Brooke Dinglejean, board member present.
Thank you. Any updates to the agenda? Okay. And now we have opportunity for public comments on non-agenda items. Is anybody, you have one, Ed?
Yes, I do.
Go ahead.
Again, for the record, my name is Ed Stanek. I'm a resident of Barre City. As I think you are aware, I'm a former employee for Act 250, District 5 for quite a number of years. I'm here today as a private citizen, although I want to mention up front that I'm also a member of an organization known as Don't Undermine Memphremagog's Purity, but I am not here at all in the capacity having anything to do with that organization. And I'm also here because of element of an appeal, but I'm not here at all to address the merits of the overall appeal, which is an appeal of a jurisdictional opinion. In fact, I'm not even going to mention the name of the case, but I will give you the docket number. The docket number is 25-ENV 00012. And I'm here because of a motion to dismiss that was filed by the firm representing the appellant in that case. And in that case, and again, I'm not at all going to comment on the merits of the Act 250 jurisdictional issue, but in the motion, the firm, which is Gravel and Shea, raises a challenge to a fundamental aspect of Act 250, which I feel could have a devastating effect should the court rule in favor of the argument. And the argument is federal preemption. And it strikes, in my view, at the heart of a fundamental purpose of Act 250 since Act 250 was enacted. And this has to do with the quote unquote supervisory role of district commissions. It has everything to do with Act 250 Rule 19. And Act 250 Rule 19 deals with the presumptive value, the presumptive proof of agency of natural resource permits and other state agencies, but it's mostly A&R permits. And that rule also allows for the presumption to be rebutted based upon evidence. Now, trying to keep it brief, because I know you have quite an agenda, during my, not tooting my horn here, but during the 30 plus years I worked for the program, I was involved in less than 10 cases where Rule 19 was used in an effort to attempt a rebuttal of a presumption. But I can tell you this, in those cases were worth their weight in gold on behalf of the public interest. Now, I'm not going to go into a song and dance about those cases. If the board is interested at another time, I can go into a much more depth, take you through all the weeds on Rule 19, but that's my purpose today. My purpose today is to express great concern that should the appellant prevail in its argument on federal preemption and basically destroy the Rule 19 process, there will be serious ramifications throughout the state. It's a statewide issue. It's not limited to the specific case. And I'm here because, and I think the board has seen a memorandum that I wrote in 2021 to the interim chair of the then Natural Resources Board, in which I raised concerns about the lack of policies, procedures, or rules on how the NRB makes decisions on appeals. I'm mentioning that as simply as background. It's not your burden. You're a relatively new board. But I'm here today because I can recount that during my career, there were times, not many, but there were times when the Environmental Board reached out to the Office of the Attorney General for assistance on issues which had statewide implications. It didn't happen often, but it did happen. And I'm not here at all to cast a doubt on the abilities of the legal counsel for the Land Reuse Board. I want to put that out front. I'm not here to challenge anybody's competency, but I am here to say that there is more muscle in using the maximum amount of state resources to refute this challenge to Act 250. And again, if I'm sounding overly dramatic, because I feel very strongly about not only Act 250, but the value of Rule 19. Throughout the legislative sessions, there have been numerous attempts to repeal 10 VSA 6086 small d, which is the root of presumptions under Act 250. And those legislative changes, interestingly enough, have never been passed by the General Assembly. I'll try and wrap it up. I'm very familiar with the firm involved in the appeal for the appellant. Vermont's a small place, right? We all know it. The firm, it's all public information. It's Gravel and Shea. I knew Gravel. I knew Shea. I knew John Ponsetto, who was a major partner in that firm, former Commissioner of Environmental Conservation. Steve Crampton was a partner there, former Secretary of Transportation. I only mention this because that is an example of the depth of knowledge in that firm. So we're up here against a significant firm, and they're trying to clear the deck. If they succeed in having the court rule in favor of this federal preemption argument, it'll essentially eliminate Rule 19. So anyway, that's why I'm here. I'm urging the board to consider, in conferring with its counsel, perhaps reaching out to the Office of the Attorney General to strengthen the response. But I'm primarily here to flag this issue. If you have a chance to look at the motion, it's on pages 13 through 19 of the motion. The federal preemption argument is there, pages 13 through 19 of the motion. So I'll end there. It's just a plea, for diligent protection of the rule.
Thank you, Ed. We will take that under advisement. Any other public comment at this point? Hearing none, let's go to consent agenda items. Review and approve of June 9th, 16th, 19th, and the 19th minutes. I thought we had 26th on there too, but I guess not. Okay, just 9, 16, and 19.
I'll make a motion to approve the minutes from those meetings with any revisions that we might discuss as a part of the discussion.
Okay,
Second.
thank you, Kirsten. I have a couple of minor comments on the June 9th minutes on page 2 under G. That's an incomplete sentence, I think, the first one. There's Peter Gill reported that the employee engagement survey from HR is open to all employees and the status of S-127. Maybe he just reported on the status.
That's my recollection.
Okay, so if we could add the words reported on in front of status there. And then had one other, maybe it was on the 26th, so maybe I don't have any more comments. I guess I don't. That was it. Any other discussion on the minutes, Kirsten?
So I had a question about the June 9th meeting, which might also be a bit of a question for Alex. In the minutes identify that Alex was not in attendance, and then further that his vote was abstained concerning the items where there was a vote taken. And I wondered if that should instead be listed as absent as a status concerning the vote.
I think so myself. I don't think that you can vote if you are, or you don't have the option to vote if you're not there. So you don't have the option to abstain. It's an absent. So I don't know if that column could be, well, maybe there needs to be another column.
Well, for that particular set of minutes, since there were no abstained votes, maybe
It can just
the
say
heading could just be changed to
absent.
absent for that
Yeah.
particular set of minutes. Yeah.
Yeah.
If Alex, like that's, you I presume you concur that you were absent for the full extent of the meeting and you didn't vote on those items.
Yeah, from a factual standpoint, that's correct. I wasn't
Okay.
there. In terms of how we structure our minutes, I don't think it matters a whole lot, but you could either, in this case, you're right, Kirsten, you could change abstain in those columns to absence, and it would be more correct. But going forward, we could potentially leave it as an abstain column, but simply have the member who's not present not be indicated at all. Like none
Right.
of the boxes are checked
Yeah.
because they weren't there.
Right.
Either way.
Or redacted or something.
Mhm.
Redact that row in the matrix.
Mhm.
Brooke,
Yeah, there is the difference between absence and abstaining. Abstaining establishes the person was there and chose not to vote. So either leave it blank or put absent. I think putting absent is more appropriate.
maybe for correcting these minutes, I would suggest taking out the X from the box and then just crossing out Alex Weinhagen the whole row. Or redacting that row since he was not there. And then that would be the case for the other 2 votes as well. Or all of the votes. There's 1, 2, 3, 4, 5 votes.
I think for easiness, I'm just gonna add an absent column and then mark him as absent and leave the abstain column. So I'll work on that.
Thanks, Maddie.
Thanks, Maddie. As
Okay.
for the June 16th meeting, since we're taking this all in one motion,
Yeah.
I emailed Maddie, suggested changes to reflect the comments of Steve Hardy, who was at our meeting and did make some comments about the wood products manufacturing study. So I just tried to capture what those were and sent them to her in an email, which I copied all of you. So hopefully, if that rings true to you, we can amend the minutes to include that.
Rings true to me.
I concur.
Was that a nod, Brooke? Okay.
Yeah, that's fine with me. Yep.
Okay. Okay. And anything on the 19th? I think then we are good to go. Any other comments on the minutes? Okay, all those in favor, please say aye. Aye.
Aye.
That is unanimous. Thank you. Operations, budget, and legislative updates. Pete, what do you have for us?
I'll just say one thing, and then I'm going to yield the floor over to Rachel with budget items. We are still waiting on position numbers for the 2 new positions, although I see it's July 1st tomorrow. So with that, hopefully we will get those numbers in short order. So yeah, with that, I'll shift it over to Rachel.
Hi, everybody. It is the last day of the fiscal year, so I have some preliminary numbers that I'd like to share with you, if that seems like the right time, Janet.
Yes, it does.
Okay. So I'm going to start with our receivables for the year. So our special fund revenue that we received this year totaled $2.38 million. Those revenues are derived from Act 250 fee revenue, also certification of actual construction costs revenue, as well as some nexus to our enforcement folks on out-of-pocket expenses for our enforcement officers that are assessed in something like an AOD. In addition to that, 2.38 million those are our special fund revenues. We assessed another $37,000 in civil penalties this year. So I'll stop there to see if there are any questions or any explanation that I need to say further.
No, no explanation. What was in our budget? Is that close to what was, okay,
So what we budgeted for in FY 25 was $2.97 million in fee revenue received. That said, because of Act 181, we were awarded an additional $900,000 appropriation because we understood that the interim exemptions associated with Act 181 would erode the revenue that we anticipated originally. So really the calculus here is 2.97 is what we budgeted. We had a $900,000 offset and we received 2.38 million this year. So we ended up ahead of where we thought we would be, if that makes sense.
yeah, thanks.
Okay. So I think if there are no other questions on that, I'd like to shift. Oh, go ahead, Kirsten.
So Rachel, do you submit like an end of the year budget report to the administration? And is that something, well, I assume there's some final, budget reconciliation report that's done?
There's quite a few different kinds of forms that are filled out on a variety of different things. We have an accounts receivable form that we need to submit to the legislature every year. And I'm happy to provide you with a copy of that when we submit it. Usually it takes, this is the last day of the fiscal year, so those forms aren't typically prepared until sometime in July or even August, depending on, that closeout process can take a while for finance and management to, wrap up these things so we can efficiently report on them afterward. But I'm happy to provide all of that to you over the next couple of months as they are prepared.
That would be great.
Okay. So I think on the other side of things, our expenditure side, there are a few areas where we received appropriation last year that we did not expend all of those funds. Specifically, there are two general fund sources where we did not do that. The first is for an appropriation that we received last year for the salaries and benefits of our new board members, because we budgeted for the board members to start on January 1st, but you all didn't start until January 28th. There were a couple pay periods that we did not pay salaries and benefits for board members, so we ended up with a surplus of hour in those expenditure categories. Does that make sense?
Mhm.
So there is a remainder of about $75,000 in that funding line item. There is also additional expenditure that we did not, or different additional appropriation that we did not expend in our base budget of about $42,000. At the end of every fiscal year, there is a opportunity to carry forward unexpended general fund funds. So the figures that I just gave to you are up for,
Carryover.
we could, carry forward. So we could
Forward,
present
yes.
a carry forward plan at the end of the year to the Agency of Administration if they approve it, they would allow us to carry forward that money to put towards an initiative. So typically, there is usually a memo that comes out at the end of June every year. I have not received it yet. I was looking back to when it was issued last year, and it was like June 28th, so it should be coming any day now. And we will have until sometime in mid-July to present a carry forward plan to the Agency of Administration to say, we could use these unexpended general funds from last year's budget towards a specific initiative next year. Whether they approve that or not is up to the Agency of Administration, but I'm bringing that to this board since there's additional money that you all can decide what you'd like that initiative to be. Any questions about that?
Yeah, Rachel, you described $2 amounts in this underspent expenses side of the equation. The board salaries for $75,000 because we started at the end of January instead of the beginning, and 42,000 in base budget. So I'm assuming that when you look at all of our expenses on the budget side, that we're in the black essentially by those two numbers. Are there other expense categories where we overspent, and meaning that no? Okay, so that's the net. Those two numbers put together. How about on the revenue side? You indicated that we did a little better than anticipated largely because of that $900,000 special.
Oh, did Alex freeze up for anybody else?
Play into
Yes, he's
the total
frozen.
amount.
Oh, Alex, can you hear us?
I can hear you.
You froze.
Okay, sorry. I'll repeat.
So you were starting to talk about the 900 because of the 900,000 supplement. Go ahead.
Yeah. So my question is, with that $900,000 special appropriation, we did better on the revenue side than we had anticipated by a little bit. Does that also play into the potential for a carry forward request, or is it just on the expense side?
No, carry forward is specifically for unexpended appropriation that you received during a fiscal year. So we're kind of looking at them differently in this case. Does that answer your question, Alex?
Yeah, it's simple enough. So we're potentially looking at a total of 117,000 that could be carried forward if we were to make that request.
Yes. Yeah.
So what's the process, Rachel? What has been the process in the past internally for us, for the program to talk about that?
Well, typically it would be something that we might talk about at a leadership team meeting, because the chair of the board was in charge of making these decisions solely. So we're in potentially a new territory here, but that's why I'm bringing this question to the board. The process is really, we will receive a memorandum from the Agency of Administration outlining this process. They typically give you a fairly short turnaround to create a proposal, but it's an annual process. So we know that process is coming, even though we haven't received the memorandum to date. All we would need to do is create a short proposal with what we would like to carry forward, and carry it forward for what purpose. And the Agency of Administration and Finance and Management would let us know in August whether our carry forward plan is approved or not, and then we can move forward appropriately based on their approval. Does that make sense? Typically, I was just looking back to last year, and I believe the submission deadline last year was August 2nd, and then they approved it, or they, approved it in late August last year. So we have
So
about
there's
a
a
month
month, yeah.
to
So
really,
I wonder if we can ask each board member to think about this and then we can put this on our next available agenda for discussion. Brooke?
So then the decision about asking to carry forward the funds is a board decision to be made, is that correct?
Believe so.
I'm just trying to figure out what the difference between this is versus the decision that was made recently about some excess funds that we were not involved in.
That was an HR that we had existing policy to, it was an HR procedure with existing policy that involved the chair and leadership team. Pete?
Yeah, I was just gonna suggest that leadership team take a crack at getting some different thoughts down for you all too. I know you all will certainly have thoughts and ideas about direction of this proposal. But I also recognize that you guys have been in your seats for 6 months and probably would appreciate some thoughts from this the leadership team as well, and we're happy to kind of put some things pen to paper a little bit and give you ideas to shoot at a little bit too.
Absolutely. Thanks, Pete. Brooke?
So is there any guidance policy on this particular topic or action that we can look to? Because the last time we got a policy like kind of after the fact, and this time I'd like to know, is there anything that we need to be following to make sure that we follow the policy correctly?
well, what do you mean by policy? Carry forward is that authority is granted typically in the appropriations bill every year. So there is a statutory nexus to granting this authority and what the process is. And we would be following any instructions that the agency of administration would issue about what kind of funds would be in bounds for us to create a plan on. It's up to the discretion of this body to figure out what you would want to spend that money on. I think anecdotally in the past, what I've heard from previous liaisons that we've had to finance and management is that typically they would like to see proposals that are not tied to year over year expenditures. That it would be this is one-time money, so we're hoping for a one-time proposal, if that makes sense. I don't think that it's completely out of bounds to propose something else, but that's the direction that I've been given before from finance and management about what types of proposals they're looking for, if that makes sense.
Yeah, I'm not worried about the proposal itself. I'm sure you guys understand that aspect of it. I was trying to understand whose authority it is to decide. So that's the kind of
board's.
policy that I'm looking at, because we have, remnant policies that say the chair decides things. And so I'm curious, is there a policy that we have in place right now that governs, financial decisions or whatever, that vests the authority in the board or the chair? Just wondering if there's remnants that we need to deal with or follow or whatever.
Not to my knowledge.
And Rachel, I like Pete's idea. I appreciate leadership team, providing some suggestions so the board can then kick it around at a future meeting. But if the board decides that we're not interested in carrying forward or asking for it to be carried forward, do we have to take any action, or do we just simply do nothing?
You could simply do nothing. Yeah.
Okay.
Kirsten?
So I was gonna say the same thing as Alex, like I like Pete's idea of like, I think I welcome board conversation around this. And I would be interested to hear if the leadership team has ideas. And on my part, I'm also, if it's readily available information, I'd be curious to just get the latest on funding for the digitization project. And I remember looking at the numbers, I think that were within the annual report, and the expenditure at a glance to me seemed lower than what I had thought it might be at this stage of that big project, but I'd be interested to know, maybe that particular project could be a candidate. So, but I'll look forward to hearing more at a future meeting. And
Yeah,
if the board,
go ahead. No,
well,
go ahead.
if a memo comes out, if it could be shared with the board upon issuance, that would be good information as well.
Yep, I definitely can do that. I expect it sometime this week. I will also just say that there is one other carry forward line item that I think we would need to create a carry forward plan for, which is a part of the digitization project that Kirsten referenced. Several years ago, we put in a proposal to finance and management to fund the next phase of our scanning project. We were awarded $1 million grant to do that, and we still have, you know, most of that $1 million sitting in a general fund line item. That appropriation is sitting there. We're expending our ARPA funded money, which has a time duration associated with it where we have to expend it by the end of 2026. So we want to front load using that federal money while we have it before falling back on this general fund appropriation. But we will need to create we will need to ask finance and management to carry forward that $1 million to next year. And just to benchmark with you all, we've been talking about Alex Pastor and I, and a little bit with Janet, we've been talking about finalizing moving into our next contracting phase with our vendor around that next phase of work. So we've been having preliminary conversations with Visara and Agency of Digital Services to kind of get us in line to start working on that next phase of work. Does that make sense? So I think at a minimum, I would hope that the board would support carrying forward that money. This other $117,000 is up for grabs for folks to decide what that money would be most useful for, if anything. Is that?
So we have a meeting on the 7th, and we haven't finalized our agenda for that, but we can add 20 minutes or half an hour or something to discuss that perhaps, and we can talk about this on Wednesday at our agenda setting meeting. Sound good?
Sounds
Okay.
good.
Thanks, Rachel.
Nice to be
Anything-
able to share good news,
Yeah. Anything else for operations, budget, legislative? Okay, studies and reports. We've got draft guidelines ready for regional plan applications. I sent that out to a few people on Friday and got, everybody that I sent it to got, returned email saying that they're out for, some amount of time. So, this is one of those weeks where there's a lot of people out. So I suspect that I might need to ask, I had been asking that people get back to me by July 11th. Maybe I'll need to extend that. I don't know. We'll see how it goes. But I do want people to look at those guidelines, and I think we should release them internally as well. So maybe I'll have Pete send that out to all staff today, if possible. And then we are still working on an application form and a comment form, and we will also be developing an objectors form. Sarah's not here to give Tier 1A report. I don't think that she has new news in that front. And Kirsten, you want to give a quick update on where you are with the wood products?
Actually, Janet,
Yeah, so
can I just ask
Oh.
a question before we
Oh,
move
sure.
on?
Yeah.
So I'm just curious in terms of who, you were saying you were sharing this with people. I'm curious, you're trying to get feedback in terms of
Yeah.
the process from like
Yeah.
a regional planner folks?
Yes,
and that kind of thing?
yes,
Great.
yes. Yep.
Thanks.
Go ahead, Kirsten.
So just in terms of, putting the final wood products manufacturers report into the final format for transmittal to the legislature, just to mention that I was counseled by our sort of data manager to really not put the exhibits as links to, a location on our website where they may not be accessible longer term. And so the decision was made to transmit not just the main body of the report, but the whole enchilada. So like all of the exhibits together with the report narrative were compiled into a single PDF, which is the legislature report filing requirement, as I also learned. And there was a simple cover memo drafted that Pete and Janet helpfully put eyes on, and Brooke too looked at it. And there was a little back and forth on, should this thing be, in this one document? And then sort of today it was learned that, yeah, we can have, that as a separate sort of transmittal. So it's on our website, the final report, and Pete is emailing it to these legislative recipients. And everyone will have that, I presume, by the end of the day. So, Alex?
Kirsten, am I hearing this right? Did you learn that the way we're supposed to submit these to the legislature is as a single PDF file? That we cannot, in fact, have the report be one PDF and the appendices be a second PDF and submit both?
That's
Correct.
right. Which was not something I was aware of until
And
recently. And
Do
so,
you know how large the PDF file was that ended up being sent?
I think it was like 5 megs. It wasn't huge.
Oh, okay,
And
that's
Alex
manageable.
Pastor said, and in reading the policy, it doesn't indicate any size limitation. It could be a transmittal issue, like you might have to transmit it as a link, but I emailed it around just kind of as a check on, make sure that functionality would work. So
Yeah,
and Janet had the suggestion to number the exhibits as like A1, A2 pagination, and then exhibit B was B1, B2, and so on. And so I learned that, how to do that, which was actually pretty quick and easy. And that's how the exhibits are compiled in the document. So lower right-hand page has all that pagination, which seemed to work. I
Great,
liked that
thanks.
suggestion.
Thanks for doing all the rigmarole with page numbers and combining files. Part of the reason I asked was because it's educational for me to understand, how we're supposed to format it, of course, being new to state government. But the other part is that the thing that really fries me is when documents like this that we want people to read are so large in terms of pages or just file sizes that it's hard for someone to actually download them at all.
I know.
A 100 megabyte PDF file is not a workable PDF file, but if you got it down to just 5 megs, then that's easily emailable and usable. So hooray.
Well, I had the same concern. And I really didn't want to have all those attachments within the one document. I wanted to have it be shorter and smaller and more nimble, but unfortunately, with the issue with URLs, I was counseled to not do that.
And, also though, we could have just the report as a separate PDF on our website, and the exhibits as a separate PDF if we would like. And I think I would recommend that because of what the issue Alex raised. If you want somebody to read something, 16 pages is much more palatable than 106 or whatever it
Yeah.
was.
Yeah,
So,
that's a good idea. Like you could have the full compilation, then just the report and the attachments as two other kind of separate options for
Yeah.
the people to download and view.
right.
Like
So we can
that.
submit it to the legislature under their rules, and we can provide it publicly in a different format. Pete, were you going to say something similar? Is that why your hand disappeared?
I was going to say the same thing. Yep.
Okay. Okay, but Kirsten, thank you so much. I know that you spent a significant part of the weekend just dealing with the formatting of this and to get it off today, so thanks. Alex?
So is there, now that it's finalized and soon to be submitted, it sounds like, or already submitted, can we update the webpage, our webpage, so that there's some sort of alert on the front page as a, here's the thing we did. So people don't have to drill down through the Act 181 overview into the wood products manufacturers. I think for some period of time, there should be a, big shout out saying wood products manufacturing study complete. Click here.
Mm-hmm.
In the cover
That's
memo,
good.
I made mention that this is our first report.
First deliverable. Pete, we can
Yeah, I was
do
just
that,
gonna say,
right?
we can put that on the what's new, under the what's new
Yeah.
banner there. Yeah, something. Pop.
And maybe not the 106 pages, but the 16 with a link to the exhibits separately.
Yep.
Okay.
I wouldn't
Thanks.
mind seeing the cover memo on the website
that's a
too
good
as a
idea,
link
too.
because it kind of
Yeah.
explains a little bit about the public process.
Yeah, that's a good idea. Okay, Alex, do you have anything to report to us?
I don't actually, not from what I reported last week. Same status.
Okay. And Brooke, we're gonna spend some time on appeals in a little bit. Do you have anything else? No? Okay. So Sarah's not here to, guess I should have thought about this earlier, but discussion of draft procedural rules. Do we want to have some discussion, continued discussion on this at this point, or would you rather wait for Sarah to be present to hear it? She said she would be listening to the recording.
I think we can certainly talk about it, but if I remember right from our discussion last week, we hit on a few points, and I think we sort of were pushing it back towards staff to work on it some more, and maybe for us to talk about specific segments. I guess what I'm saying in a roundabout way is I'm not sure what it is that we have queued up for discussion today, but I'm happy to talk more about it if people want to.
Yeah, I think Brooke in particular had asked that we get some instruction around buckets, what belongs in which bucket, rules versus guidance versus policy. What do those words mean? So we can come back to this after that, unless people have specifics that they would like to discuss today on the draft as it was, the preliminary draft that was presented last week. Kirsten?
At this time, I don't have any other specific substantive feedback. I feel like I think we would sort of benefit from a continued walkthrough a little bit, like sort of along the lines of what got underway with the communication plan. Like I think there can be further. It's quite sort of like an early draft of, and
Yeah.
so, but I feel like it would be better if Sarah is with us, since she's the one who is involved in all this, like to have that continued kind of walkthrough and discussion.
Yeah, and didn't we talk about a training of some sort on
Yeah,
the
we did.
buckets that Brooke was
Yes. Yeah.
talking about? I think maybe that's what's getting my memory going. I think it makes sense to wait for that to happen before we dive in again.
Okay, and just, and we did, for Rebecca's sake, point out a few things that we had remembered from the first time that we discussed this as a board, and one being that we didn't want to refer to Robert's Rules of Order or even the Robert's Rules for small bodies, and two, that we wanted a removal decision to be unanimous. So other than that, we didn't really have substantive comments. So, okay, let's move on then to appeal study summary and discussion.
So, as you all know, we have completed 4 stakeholder meetings that we had calendared to try to move through the appeals study to focus on the charge. And I'm going to share my screen just to briefly go over it. Not that we need a huge refresher, but just so everyone, including the public's on the same page. Can you see that okay?
Yes.
Great. Let's change screens here. Okay, so I'm just showing the summary of the process document that I've been updating periodically as we've been going through the study. And just to reacquaint ourselves with the charge, in the first instance, we have to decide and make a recommendation whether to allow consolidation of appeals at the board or with the environmental division of the Superior Court. And then how, if transferred, the decisions for Act 250 zoning and A&R permitting could be consolidated at the LURB or a board.
Are you
So-
okay with questions in interrupting your summary, or would you rather?
Absolutely. No,
Okay,
no,
well,
absolutely. Yeah, I'm
Alex,
sorry. Let me look. Let me get
has
you
a-
guys maximized so I can keep my eye on you.
Okay.
Because my
Thanks, Janet. I appreciate that giving Brooke the ability to say no questions yet. So Brooke, the one thing I wanted to point out, and it's a minor point, but for some reason it sticks with me. So I just wanted to say it. Most of the documentation and on our website about this study refers to the what's under B on the page that you're sharing right now, what the report shall at minimum recommend, right? So it starts with whether to allow consolidation and so on and so forth. But I do think it's important to remember what comes in A, which is, I think, the actual, first and most central charge for this study, which is whether to transfer appeals of permit decisions and JOs issued under the Act 250 program to the board, or whether they should remain at the environmental division. So, like, in my mind, that's the central question. And then the legislature wants us to also address, these other items at minimum. And so I just don't want to lose sight as we go through this and we start to firm this up. I don't want to lose sight of the forest for the trees. So that's all I wanted to point out.
No, that's really a great point. And it's folded into, examining models and that kind of thing. But no, actually, that's really important. I'm glad that you pointed that out. Thank you for pointing that out. Yeah, in the first instance, the question is to evaluate whether or not Act 250 appeals and JOs should come to us as opposed to go to the Environmental Division. And then the notion of one-stop shopping comes into it. And then also, can you conceive, or what would you recommend for consolidating appeals? And in the beginning of the study, we went around in circles a little bit on consolidation and coordination. And really, the upshot is that the notion is to be able to have a venue that for a project that had multiple kinds of permitting and appeals on those permits, if there were the ability to adjudicate them at the same time, as opposed to having to go through separate appeals. And again, that is something that is very case dependent, depends on what the developer, how they want to approach their permitting. Often zoning goes through much quicker, even if they're started at the same time. So that issue was sort of not focused on, because whether it's a board or a court, we have that opportunity now, and there's no reason why we couldn't offer it. Having said that, there are very limited circumstances, small number of them, that actually get consolidated, where one hearing is had and then the different permit appeals are decided. But it is good to have that as an option for folks. And then we, at a minimum, we need to recommend how to prioritize and expedite appeals related to housing projects. And what we saw in looking at statistics are that there are very few housing appeals, but some of the ones that have happened have been extremely long, arduous, and communities are very concerned about them because they involved a lot of community planning for years, and then felt that it was held up on appeal, by either, an individual, whoever might have had standing. So let me just finish going through the charge. The next thing they wanted, number 3, is procedural rules. So that requires that we figure out what model or models are viable, and then we can build, the board rules. But we need to understand what the components are and what the structure of the board or board models that we're going to pursue. So procedural rules are sort of the last thing that we would flesh out once we have more direction on which aspects of which models are palatable to the board and would like further study, so that we can focus in and start to drill down in a funnel to isolate what the components are, which structures are the most feasible. And then ultimately, when we go beyond finding that model, we are now required to conduct a financial analysis to determine what the cost would be, so that while we can look at a benefits versus burdens analysis, we know the actual costs of being able to convert over to a different system. And then lastly, of course, there are other actions that we should take as a board to promote efficient and effective adjudication of appeals, including any procedural improvements to the Act 250 permitting process and JO opinion appeals. So we also have to focus in on our own processing. Is there anything that we can do to help move that process quicker through the initial adjudication and decisions by our district commissions or coordinators? So in terms of where we are right now logistically, yep, Janet?
Sorry. So the new aspect of this from this year's legislative session, the cost analysis, what do you anticipate we will need to do that? Who do you think we will need to go to get the information that we need to do that?
Yeah, we talked very preliminarily ages ago now, Rachel and I, about being able to obtain the information for comparison from the judicial branch. Pardon me. And because in looking at, I did research on, the annual reports of, the budgeting at the judiciary. And the problem is it's not like categorized according to which court, like civil division versus environmental. So we need to reach out, she and I, to the judiciary to see if we're able to isolate those, what are the operational costs for the environmental division. And I think that will do two things. It will certainly help inform us in terms of volume of, just documents in terms of the computer platform needed to process things. But we also need to understand how much support staff, how much personnel are used to process the actual appeals, so that we can determine what, in addition to our current staff or staff that would be reassigned to different tasks, we need to make sure that we understand who needs to do what, how much bandwidth for the computer, platforms and all of that. So we wanted to get through the stakeholder process to understand where we were kind of going for this, so that Rachel understands, all right, if we're looking at X kind of model, we need to be able to say, all right, this is how the model will work and who is going to do what. And that way we can assess what our own personnel needs are in the first place versus then the comparison. So she and I need to get together with Judge Zone and see if they're able to give us sub information about the overall budgeting for that.
And is there information that the PUC might have that might also be relevant in terms of hearing officer models and whatnot?
More from just a context kind of thing in terms of data, or, they're just so much bigger than we are. They're like 2,800 cases a year. They have 15 hearing officers. So they, while there are some aspects of their structure that are being considered and thought about, trying to use any comparison is just too difficult in that, because they're just so much bigger. I think is where we came out on it. But Allison and I did meet with Steph Hoffman, their general counsel, and she had good information about the need or lack thereof on firewalls. And, we really had a good conversation with her because, they're in that model in terms of having decisions by a front level person who then it's a recommendation to the commission. But, we talked with her about what about the lawyers? Do they have any issue or difficulty? Do we have to say, if you help the district commission, you can't help the appellate board, that kind of thing. So it was a good discussion. She brought forward, she thought that part of it might be related to the role that the lawyer plays at the lower level. If they are just consulted for, gee, could you help us research this issue? That would be one thing. But if the lawyer is authoring a decision, for example, which is not expected in our structure, but that would be a little bit different. That would be helping to review your own decision making. So the role became kind of the central issue that we thought might be of concern. Allison, you got anything to add to that?
No, just that Steph Hoffman did clarify they're not hearing their own appeals. They're sort of, they are a different structure where the hearing officer's issuing a recommendation for a decision. So it was definitely a very helpful conversation, and there's some lessons learned from their model, but it's not completely analogous. So.
And I think she helped to clarify, at least in my mind, that, the conflict of interest is about the decision maker more so than anything else. It's about the board. And if we're setting up a system where we are an appellate board without any direct control or input to the district coordinator or commissions on their decision making, then, that's the kind of conflict that is concerning in terms of making sure that you're not reviewing your own decision, is an easy way to put it. And I think Allison and I felt pretty comfortable with, obviously it depends on the exact structure, but that seemed to not be an issue unless, obviously there was some ethical conflict that one would have to recuse themselves from. Is that fair to say, Allison?
I guess I was trying to, which part is not an issue? The lawyer working on it, if they're not the person that's rendering the decision?
Or
No, in terms of the board, as long as we're isolated as an appellate board and are not having any contact or control over the decision maker below. That was the kind of firewall protection that we believe is of concern to the legislature.
Yes, and yeah, and you had flagged the firewall language uses the term the board and not council, for example.
Right.
So yes, I agree.
And there are a number of other, the other thing we're looking at are other kinds of boards and their legal staff, human services board, all those kinds of situations. So, but we will continue to analyze that and make sure that we provide the kind of protections that we would need once we get to board rules. So at the present, just logistically, Alex Pastor has been helping me. She's like my admin assistant for this study. And I talked with her this morning about creating a template for the report and also for her assistance, because I don't think I have the skills that Kirsten may have in terms of fixing everything at the last minute and making sure all of the document is up to snuff. So in terms of her assistance, I'm going to be providing text and having her insert it into the template. And I suggested to her that we need to, in terms of the way we lay it out, needs to be consistent with wood products, like the board was talking about. So she's been terrific. So as you know, I don't know if sharing the screen is helpful for you guys or not, but what I wanted to do was just switch to looking at just, hold on, let me get to the board models. Okay. So during the stakeholder process, we looked at the existing court structure for appeals. We looked at a transfer of jurisdiction, enhancing what the environmental division would be reviewing by adding real estate type tort actions, rights of way, all those kinds of cases that are normally under the civil docket that would be transferred to the environmental division. So it's not specifically necessarily within the requirements of our study, but it is suggesting that to not only stay with the environmental division, but to increase their jurisdiction. We then have which one am I in? Yep. And we have a board model for the Act 250 jurisdiction only, which Alex was alluding to and as the beginning of the charge, just showing in a picture how JOs and commission decisions would go up to the Land Use Review Board. And then our decisions would be reviewed by the Supreme Court. That is the way that the PUC operates. The commission gets a hearing officer decision that's completely written out, and that's the recommendation for the decision. And the commission decides whether or not they accept that, reject it, or modify it. And their final decision on that is then appealable to the Supreme Court. So MSK, Liam Murphy was nice enough to depict this for us. They are not recommending that. They would like enhanced court jurisdiction and would like to stay with the court, and have made very compelling arguments for it. So then we have board model number 2, which is an ALJ model from David Mears, who has a lot of administrative law experience. And this separates A&R decisions and puts them over in their own, sort of like the PUC, going up to the Secretary of A&R, and then that decision going to the Supreme Court, like the PUC would have an appeal. Now, let me insert here in our conversations with A&R. First, they are not interested in leaving the court for their appeals, and they also were not interested in changing their structure so that the A&R secretary would be the appellate body. So this is not the secretary notion is not something that A&R was receptive for. So then I'm going to, and the thing about David Mears's model is that it also segments the kind of decisions that are being reviewed. Yep, Janet?
Can you go back to the previous administrative law judge model depiction? Who would these administrative law judges be?
That's a good question. And so it could be a member of the LURB. It could be one of our lawyers. It really, that's where the categorization and to sit down and say, all right, if we have zoning cases, you know, what kind of zoning cases are we getting? We're getting like simple setbacks or ones that are very simplistic. They could be probably adjudicated by a single hearing officer or ALJ. The thing is, I want to caution you, don't get hung up on the terminology. It's really more, what would this individual be doing? And so, for example, if we thought JOs, you know, and I'm not sure this is a good example because some JOs could be really complicated, but are there JOs that could be heard by an ALJ? Now, this particular picture does not have the ALJ deciding it. It's just like the PUC with their hearing officer. Oh, okay, here's my recommendation. And then it would go to the Land Use Review Board for us to say yes or no. And then again, it would go only to the Supreme Court. It cuts out the trial court.
So what's the difference between an ALJ and a hearing officer? Is it just a matter of semantics?
Well, you know, so administrative law judges, that's like a title, okay? And often they're lawyers, but not always. Like at the PUC, they have 15 hearing officers. A lot of them are lawyers, but they're not all lawyers. But they are very acquainted, obviously, with, you know, the PUC statute and everything. So in my mind, I'm not getting too hung up on the name of it, but, you know, in the administrative law area, remember, we're in the executive branch. And what the APA, the Administrative Procedures Act, does is it establishes rules that we have to follow when we adjudicate cases. So our district commissions have to follow it. You know, you got to make factual findings, conclusions of law. You have to have due process for your hearing, all of that stuff. But it allows you to have some relaxed standards. You can prioritize housing if you want to put them to the front of the line in the, you know, in the queue. You can reduce the amount of discovery. You can put deadlines on motions so that things don't get filed ad nauseum for, you know, in a serial fashion or what have you. So, you know, these are kind of picture snapshots, try to give us an idea. And the reason why I wanted to come back to the board at this point is for this very reason. What about this? Who can we put in that? How do we create enough capacity? That's the other thing. is that we have 5 people here. The environmental court has 2 judges, and each judge is fortunate to have a law clerk. But we are more decision-making, we have more capacity, but the question becomes, how do we as a board figure out how to create that capacity? I mean, if we're sitting as a board, hearing every single case, well, that's not as effective as 2 decision makers in the environmental division. So let me move the cursor here.
Unless we are only hearing Act 250 appeals.
Well, unless we become, well, this isn't a good picture of it or anything. So let me just go back up. Unless we create hearing panels or hearing officers, because like in a municipal appeal, we could assign 3 board members to a panel. And this is duplicative or mimicking our Supreme Court in Vermont. They have 5 justices, but not every case goes to 5 justices. They have what's called the rocket docket. And what they do is they assign 3 of their justices to a panel that makes a decision on the cases that are less complicated so that they can move a lot more cases through the system. And that way, instead of all 5 people sitting on every single case, each person is responsible for X number of cases in different configurations. Therefore, lots more can be adjudicated. You can increase your volume that way because, Janet, you might be sitting on, 10 zoning appeals, 2 JOs, and you're going to sit on the full board, for 20 of those cases. And so will I, so will Kirsten, so will, all of us, but I'm going to have different cases than you would. So what we do is we figure out how do you create panels to adjudicate these so that you can push the volume through quicker, but still have the right composition for a 3-member panel. If we have a case involving floodplain issues on a zoning case, then Sarah or Kirsten would be a great choice because of their background and information, knowledge about that particular topic. Because the pro of having this professional board is to be able to use the various expertise in combination. And if we can then bear those expertise on the right cases to be able to not only prioritize them, but to get great consistent decisions by people who have the background knowledge and experience in these different silos or arenas. For example, if we were doing an Act 250 case, I think that Kirsten as our Act 250 expert, or me as someone who's also, has a lot of knowledge of Act 250, should definitely be on that panel. But if it pertained to, something that was deep in engineering, let's get our board member who's an engineer on that panel. So it's a dance about how do we figure out what kind of capacity we have. And I think that begins with going back into the data and looking at the cases to better categorize them so that we know what we're looking at. Okay, there's a group of cases that are pretty simple, setback issues, very simple zoning stuff. That might be one category. There's JOs that are pretty straightforward, and there are JOs that are pretty complicated. And get some data so that we can compare, what the issues were in the cases, or and that's going to take some more time. I've been picking through the docket numbers that we have, but when I started it, I didn't go to that level of detail for the research. So that was sort of my thinking, is that I think we need a little more data to try to categorize what cases would be if the whole enchilada is coming to the board, or maybe not A&R, but if zoning were being added to Act 250 for our review, to understand what the chessboard will be. and how we can address those to determine, can we do it quicker? Can we handle the volume? What if the volume increases? But without a little bit more clarity on, everyone sits there saying, oh, there's different kinds of cases. Well, we need to start to understand that better, I think, in order to figure out if this kind of board model, other than just, sure, we'll sit as a board and review Act 250 cases. Frankly, I don't think that the volume would warrant, this is just, kind of looking at knowing that there aren't that many appeals in a year on Act 250. It just seems to me that, and I'm not discounting it, but taking only Act 250 appeals with being so top heavy, I don't think is justifiable necessarily. Now, what happens in the future with the volume, that becomes, it's a guess at this point, but but with tier 1, I would assume permitting is going down. That's what we are expecting, volume wise.
Alex,
You said the ANR is not interested in having their appeals of their permits be adjudicated through their secretary and then on to the Supreme Court. Why? Did they explain why?
Well, there's a statutory change that would be required because they're set up in the statute a little different. I think all authority is given to the secretary of ANR, and then she delegates the authority. So, what it would entail is like for the commissioner of, part of, whatever division of the agency to be, that's the decision maker in the first instance, so that then the appeal can go up to the secretary, who's, supreme above everybody at ANR.
Is that their concern, or is that just your observation?
No,
they said that. Yeah.
They said that it would require the statute to be changed, which is true.
Right, but the statute is going to need to be changed with whatever we do if it's not retaining the current model. So that's not a valid argument.
Right.
With all apologies to ANR participants, I don't buy that argument. There has to be something more substantive.
Yeah, I think that wasn't necessarily put forth as their one and only argument. I think it probably has more to do with capacity.
Right. Yeah, they're going to get back to us probably in a week or two, because I sprang this on them last week at the meeting, because they had given us a written position about not wanting to leave the court. And so what I said was, gee, now that we have some models that are talking about using the secretary, do you have positions on that? And so they just told us verbally, no, I don't think we're going down that path. But Billy said that he would get back to us with, an actual written response and why they don't believe that would be preferable to them.
And I asked because I drew some conclusions after reviewing all the summary, and I can walk through them. But my other question was municipal appeals of municipal permits. Those have always been with the court, right? I'm not missing something there. There wasn't a time in history when municipal appeals of municipal permits went anywhere else. Is there?
Correct.
Or was there?
Not to my knowledge.
Yeah. So the idea of returning Act 250 appeals to this board, in the sense that we are the environmental board, even though we're different, that we have past practice and precedent on. We have no precedent for a board like this reviewing a municipal appeal.
Right. No, that is correct. And
then my other question is, when looking the stats on the environmental division's number of appeals, number of cases I think are really illuminating, and enforcement appeals are a pretty decent chunk. what the environmental division has to do, whether it's enforcement of an Act 250 permit or enforcement of an A&R permit or enforcement of a municipal permit. Most of them appear to be municipal permit enforcement actions. No one's suggesting that those would be moved anywhere, right? All of those enforcement appeals of enforcement actions would stay with the court in any model that you've discussed.
No, we have not actually discussed peeling off enforcement. We have been talking generally about and showing the statistics. Yeah, they are broken out to enforcement versus permitting. So no, we have not dug down into that and drilled whether or not enforcement in and of itself should stay with a court versus not. And let me just back up a minute. In terms of your question about has it ever been not in the court, keep in mind though, I mean, it used to be in the civil division and then it went to the environmental court and now the environmental division. But yeah, it's always been in the court system as far as I know for all the appeals.
Okay. Yeah.
Yeah, and the one thing that I do want to say is, you know, on enforcement, in my experience, it tends to be, you know, it's not the same big case as permitting. Often it's more pro forma. It's more, you know, a shorter time at the court, not as complicated. So, and we can look into to see if that is the case because, you know, stuff can happen on appeals with all sorts of discovery and motions, but it tends not to be as voluminous and doesn't take as long.
But I think from my limited experience, it seems that enforcement, you know, requires involves the levying of penalties and the, you know, court orders to compel someone to behave themselves or follow an order or whatever. It seems like that is the proper purview of the court rather than this board or any other version of you know, administrative law people or hearing panels or whatever. So I just wanted to clarify that wasn't really on the table, and you're just saying it hasn't been discussed as of yet. The focus has been on permit appeals, not appeals of enforcement actions.
Yeah, and that's a great point. Seriously, I mean, something that I hadn't really thought about in terms of, yeah, the court's authority and jurisdiction, and then, yeah, it may be that we would have to, if you were going to put those to the board, we would have to be creating, you know, rules that give the board authority to do things. So while we have that to some extent in Act 250, I mean, it's, you know, but we got to go to the court to get them to do something. But really important. Thank you so much for pointing this out. I hadn't really thought about it. Kirsten?
I was just gonna sort of touch on that the scope of municipal appeals struck me as so significant. You know, you were saying a little while ago, oh, well, if it was an Act 250 appeal, you would have, you know, one of the board members with maybe deeper Act 250 specific experience versus if it's a municipal appeal under the board model, you know, we've got the, you know, current board members with that deep experience, but I'm wondering, so under the administrative law judge or hearing officer or whatever term, if there are some that can have the more maybe simplified, maybe more expedited path of that one person who's the advisor or potentially the decision maker versus like a more like a full board review of maybe a preliminary recommendation, or maybe it's just the board itself conducting that review. I think if it's a more expansive, more complicated issue, it would be the type then that would more lend itself to the full board review and discussion and decision, or, you know, if it under the board model. So here's my question. Do you think there's a way to determine in terms of the typical, like the volume of appeals that are currently funneling into the court system, we've got all the numbers, or you've, compiled all that information, and that's like great research. Thank you. I'm wondering though, if how feasible it would be to look at it a little more closely and determine kind of what percentage are straightforward. Like say it's a zoning appeal and it's a setback issue and it's, supposed to be 50 feet and it's just a straightforward conclusion of, well, they only had, 49.8 feet or whatever. And then that's a simple one, presumably, that one person could readily reach a conclusion on, versus the ones that are more complicated and robust and be more suited to potentially like a board review. I'm just kind of wondering if that, like how difficult would that research be to do? Would it make sense to try to think about what does that picture look like? And is it anything that if you think it makes sense to explore some of that information, maybe through some kind of like random sampling of the files, is it anything you would like me to help with? So I'm just kind of.
Yeah, it's going to take time because it is, and our Act 250 cases, at least for the past 2 calendar years, Jenny has been keeping track of with really good information. So we wouldn't necessarily have to do much to supplement that information, but it's the zoning cases that we would have to spend time on.
So on the zoning, Sarah and Alex and I have been in municipal zoning for a long time.
Right.
And my experience is that a simple zoning appeal goes from the zoning administrator to the DRB, and then it may not go any further. And the stuff that goes to the environmental court is not necessarily simple. I can't imagine that you're just going to see a setback case at the environmental court. Yeah, it's too simple. It's not going to get that far. So
you stole my thunder, Janet. That's exactly what I was going to say.
Yeah.
There's a false
Yes.
premise being peddled here, not intentionally, but there's no such thing as a simple case in front of the environmental court from a municipal appeal, period. They're all complicated. They're all contentious. And to think that you can sort of segregate the simple ones, there aren't any, and there are no setback cases. Don't stop using that term. Setback cases do not end up in environmental court. So yeah, beware.
Maybe they're part of a boundary dispute too.
Well, I mean, you might get a case in which I think there are still, if I may say so, there are still municipalities that don't understand variance and how limited they should be. And so maybe you would get a simple variance case, because I think there are municipalities that don't understand you do not give a variance unless that landowner cannot use their property, otherwise. And that's why we have waivers instead of variances now. But other than that, I can't think of why you would be seeing simple cases at the environmental court come out of municipal zoning decisions.
Yep, no, I agree. And I was given the examples that we heard at the stakeholder meetings. I agree. Yeah, it would be very unusual to get just a setback case. Annette?
I hope it's okay for me to weigh in. I see you're
Sure.
about 5 minutes away. This topic of enforcement cases is sort of a pet peeve of mine, because when this legislation was being considered, I testified in the legislative committee and said, one thing that I was not seeing in this shifting of Act 250 jurisdiction to the communities was what's going to happen to enforcement. And so that is not something that we've talked about in the stakeholder group, but Alex bringing it up is, it does raise the question. All of these municipalities are now going to be charged with enforcement, and they're going to supposedly have to have the capability to do it because they're going to be implementing. And so what does that mean for?
They are, that is in their jurisdiction now.
It is, but a lot of municipalities don't have the capability to do it, and so a lot of times they simply don't. That's my experience. So, I mean, my point was to the legislature, we are losing an important function of the of Act 250, where there is enforcement of Act 250 permits, and what does it mean when that's shifted? So when you look at the volume of appeals that, or as Alex pointed out, the enforcement cases that may be handled, how is that going to change when, with the exemption and with municipalities qualifying for doing tier 1
Oh,
themselves?
I see what you're
You
saying.
see what
and
I'm saying? Yeah.
Yeah, now I do. So, and Sarah is exploring that with the tier 1A stuff. And you might want to express that concern to her. It's something that the tier 1A guidelines will certainly be
It does.
looking at.
What it doesn't address is the cost shift. That's what was upsetting to me in the legislature, was that I see this as a cost shift to the municipalities and taking away the state's enforcement capabilities. So this is not just about appeals. It's also about what happens with violations of Act 250 permits that are now going to be administered by the municipalities. But it also does go to perhaps the increased number of municipal appeals that are going to be seen as a result of this shifting. So there are my thoughts on that.
Sarah is going to listen to this recording, Annette, but you might reach out and have a discussion with her about that.
Right. Or she's welcome to contact me, whatever works.
Okay. Alex.
So this is great discussion, and I wish, it's funny, you know, there are some meetings where I have less to say, and this is one where I feel like I want to say more, and like we could spend more time talking about it. In part, Brooke, because I feel like we're at an inflection point with the study, right? We've had 4 stakeholder meetings. There's been a lot of input expressed, and yeah, there's more research to be done. There'll always be more research to be done. But to some extent, like the board needs to give you some direction so that you can take it the next step, maybe get a draft together, get the stakeholder feedback on some substance rather than just continuing to talk about possibilities. So I like the discussion, but we're running out of time. So I wanted to just give you where I landed after spending the morning looking through all these goodies. So here's my list. I broke it up into, generally good ideas to consider further, and places where I needed more information before I could know whether there was a good idea there. And you may not be shocked to hear the first one. It seems like having A&R appeals to work their way up through the secretary and then on to the Supreme Court is an efficient, easy way for A&R to take full responsibility for their own permits and get them out of the environmental court. So I like that idea. I'm surprised that A&R doesn't. That's why I was asking before. I like the idea of this board being responsible for appeals of jurisdictional opinions. It's always bothered me that those JOs go from a coordinator to the environmental court and skip over the commission and skip over the board and go right to a court when we know our jurisdictional triggers better than anybody. So I feel like jurisdictional opinion appeals coming to us is a good idea. That's one of the model components of some models. I really like Jim Dumont's suggestion about the Rule 5 changes, where someone who's filing an appeal actually submits their statement of questions along with their notice of appeal. They have 30 days to do it. And it's very often when an appellant waits until the 29th day to file their notice of appeal. And then we have to wait probably another month to hear what the issue that they're even appealing it on is. So I like Jim's suggestion on that front. Similarly with the cross appeals filed within 14 days of being provided notice of an appeal. That seems just eminently logical, and he's right. It'll take probably 5 weeks out of the whole time horizon. So I like that change. And as we were discussing before, I do think that enforcement appeals probably have to stay with the court. So if there's some model that we end up with where suddenly there's no environmental court anymore or environmental division, that's problematic to me, because I think we need a judge handing out fines and telling people they're in contempt and, issuing orders in that way. I'm ideas that I'd be willing to consider. If we were to stay with a court model, at least for part of these appeals, recommending that the legislature provide more resources to the court, a third judge, a third law clerk. One of the stakeholder meetings I was at, that was mentioned, and seems like a no-brainer if the court's going to continue to maintain a number of appellate functions. I think there was also sort of an out-of-the-box suggestion at one of the stakeholder meetings where folks said most of the review of projects and the heavy lifting starts at the municipal level, right? Projects typically get their municipal permits first before they come to Act 250. And in fact, our own Act 250 process kind of makes that happen, right? Because we say, if you need an A&R permit, you really should get it before you come to us, or we're going to have to condition it or whatever, similar with the municipal permits. So I kind of am attracted to the idea of, if that's the protocol in Vermont generally, then the same provision in the appellate rules that says you have to participate in the municipal hearing in order to be able to appeal any decision of the municipal body. I'd be interested in the option of, the only way you can appeal an Act 250 permit that required a municipal permit is if you participated in the municipal side of the conversation. I know they're two different permit processes, so there's due process concerns there, but this is one state and, we generally know how things work. So anyways, that's an idea that I'd be willing to consider. I am concerned that municipal appeals have never been in another model other than the court, and they are 50% of what the environmental division handles. So to bring 50% of their workload into a different model like us really, really gives me pause. And so the idea of splitting, Act 250 appeals potentially with us, A&R appeals with the agency, and leaving municipal appeals with the court, I think warrants, consideration. But like Janet, items I need more information on, I really don't understand the benefit of hearing officers and administrative law judges. It feels like adding another layer to the cake. And I'm not convinced that the efficiencies that you could gain through that actually counteract that additional layer of that happens, especially if those folks are just making recommendations to a board. And I know the five of us, we're all going to have pretty strong opinions if we were reviewing something, and we're going to pick those things apart, even if we have someone before us sort of serving it up on a platter. So I'm not opposed to it. I feel like I need more information as to how that would actually be a net positive. And then the last thing I sort of want more information on is there a way? I feel like expediting housing appeals is a clear charge in that the legislature gave us, and that language is not specific to either a board model or a court model. I read that language to say, regardless of which way it goes, tell us being the legislature, what should we do to help expedite housing appeals? And so I'm curious what it is that we could do in either of those models. And for example, if the court model were to be retained, what could we do to expedite housing appeals? Is it just applying more resources like an additional judge, or is there the ability to have a housing board of appeals like New Hampshire has tried within our court model? I'm not sure if the model, that option, for example, depends on which model we recommend or end up with. So I feel like I'm interested in hearing more about the housing side of it. That's it.
Thank you, Alex. We're a little over, but I think that we should finish off by maybe me, Kirsten, and even Brooke expressing our sort of opinions like Alex just did. I feel very similarly to Alex, for instance, in terms of taking on municipal appeals. I feel like this board is implementing major new jurisdictional changes. We do not know yet you know, the results of this in terms of our program and how much capacity we'll have or we won't have. And we are also taking on this new role of approving regional plans and regional future land use maps and Tier 1A requests and Tier 1B requests as well. And we will, you know, be in charge of promulgating rules around all of these new procedures. We will be in charge of maintaining a GIS jurisdictional database for Act 250. These are all new things, and taking on municipal permits, municipal permit appeals, I think it's just too soon for us to be able to make that recommendation. So, and I just, it, as Alex says, it gives me pause. I think it's too soon to make that recommendation in my mind. Kirsten, do you have thoughts to share?
Let me just ask you before Kirsten talks, Janet, when you, are you talking about, like, we don't have enough data because it's too speculative at this point in terms of how this is all going to sugar off? Or are you saying because we have all these tasks to do, we couldn't become an appellate board anytime
I'm saying we don't
soon?
know. I'm saying
okay.
we have all of these new responsibilities, you know, maybe after a few years when everything is set, you know, for the first time, you know, at least the initial settings are set, maybe we'll have a lot of capacity and maybe we could consider this then, but I don't feel like we're anywhere close to being able to consider it now, considering that municipal appeals are the, you know, the majority of what the environmental court sees. I also agree with Alex on the A&R permit scheme. Like, why shouldn't it be, you know, why shouldn't you make that change and have it be under the jurisdiction of a commissioner and then it goes to the secretary on appeal? But, and I would be interested in hearing what more Billy has to say on that. But Kirsten, do you have some comments at this point?
I guess if it's okay, with Brooke, I would prefer to hold off and kind of ruminate on what I've just heard from you and Alex, Janet, and share some thoughts at our next meeting about this when Sarah will also have an opportunity. Would that be okay?
Sure. Oh, and I
Okay.
did want to say one more thing. I think that our board taking Act 250 appeals is a good idea. So I think it could have positive effects on our program, on the consistency of the program, the clarity of policy that this program might have, and just, yeah. So that I like that idea. But
Yeah, and I'll say that I agree with that.
Brooke, do you want to add any final thoughts before we move on?
I'm happy to just very quickly respond to some of the things you and Alex have talked about. I agree with you on A&R. I don't understand why they wouldn't want that within their program. JOs to the board, I think that's a great idea. Rule 5, no brainer. Enforcement appeals still going to the court. Well, that depends on, you know, it all depends on what's left in the court's jurisdiction, but if not, civil division is fully capable of handling enforcement actions. And I do appreciate the notion that a court would be a much better venue for enforcement. I will say that there's not a whole lot that anyone's come up with for the court, and that is in improvements because, you know, Judge Walsh has testified, well, other than giving us another judge, we still have the backstop of due process. That's the challenge. That's the biggest challenge of staying with the court process, is that you are limited in your ability to either require the judiciary to prioritize and put a housing case before anybody else, as well as to limit discovery and then to tighten up timeframes, not to give people from now until the end of the case to file motions, all those kind of deadline issues. So there are pros and cons, but in terms of helping the court to speed up, about all we've heard is Rule 5 and then give them another judge. And particularly if they explore this notion about, other kinds of cases coming in from property disputes. Now, I disagree with, I don't think there's any way to require standing in both zoning and Act 250 in order to qualify. I don't agree with that at all. They're two totally separate venues and authority and everything. One's municipal, one's state. And I think the hearing officer, remember, that is something that's mentioned in the charge. So the notion that there are other configurations to speed up appeals, I don't want to lose that notion, because I think we are more flexible, could be more flexible in that regard. Now, I agree. There's no way that we could become an appellate board for probably, 2 years minimum. And there is definitely speculation. But I think that what we need to do under these circumstances is not worry about how things might change, because at this moment in time, it's at least to give a report for, could the board do this? And if so, how? So I think that it's still incumbent upon us to take all the information we're getting about building a board model and take it to its conclusion, so that we can sit there and say all of the issues that you're talking about. Because while I agree, it'd be great to have Act 250 coming up to the board for JOs or for appeals, the problem is one of there aren't enough cases. And if it's going to further get diminished by Tier 1, 5 board members are not needed to sit in judgment of an appeal when they're only, right now they're only 15 a year. So it does not make sense, just doesn't pass the straight face test to me, to keep a board comprised very, the composition of this board was thoughtful and thought out by the legislature to be sure that there were complementary expertise. So there's lots to continue to think about here. What I'm hearing is ALJ is probably not the idea that we want to follow necessarily. Maybe a rocket docket, maybe there's panels to look at, but and some other things that have been suggested is like, let the applicant ask for the full board or for a panel. There's lots of different ideas circulating. But this is really helpful. It's useful. But if you can answer one more question for me, like a rapid fire. One thing that that's been debated ad nauseum is on the record versus de novo appeals. And honestly, I feel like, this is my personal opinion, but I think we keep the status quo as much as possible. If, leave towns however they are. If they're on the record, great. If they're de novo, great. Act 250, I think we do have absolutely the capacity to do it on the record, plus a little hybrid kind of thing. So if we can put this back on the agenda, maybe for next week, we don't have to do it at the next meeting, but let me take what you've talked about and do a little bit of maybe a little outline, some specific questions I think we need to talk about. Because I hear everything that you're saying, and I don't want to spend an enormous amount of time on something if that's not the direction that the board wants to go in. Because there's lots of digging into data and stuff that I can do, but I don't want to waste resources in that regard.
Right. I think can't remember. We may have time to bring it up at our next couple of meetings next week. So, let's do that. But let me just open it up to any public comment before we move on. Okay, oh, Annette.
Yeah, I'll offer one comment on what you all were talking about, and that is what I have heard from the lawyers during the stakeholder process about the court process and what holds things up is very similar to what I see at the PUC, and that is discovery and motion practice. So there are many, many ways that attorneys can drag things out, and those who know how to do it and want to do it do that to the maximum. So my understanding of the old environmental board was that discovery was not used that much. And I don't know about motion practice at a board as opposed to court, but I'm certainly seeing a tremendous abuse of motion practice at the PUC. And so if one wanted to do something to speed up the court process, I don't know what opportunities there might be, but putting limits on the ability to drag things out through discovery and motion practice may be one way to get more directly to the case itself.
Thank you, Annette. Anyone else?
Janet, can I just follow up Annette's comment real quick?
Sure.
So, Brooke, I get the issue with separation of powers and what the legislature can dictate to the judicial branch, which is not a lot. But I hear it talked about often in ways that make it sound like there is no way to change the judicial protocols from that branch of government, which is incorrect, right? It's just that there's a different body that sets those protocols. So is it not appropriate for us to potentially recommend to the legislature that they work collaboratively with the judicial branch to amend whatever those protocols are in order to make this process work better at the court side? Like, isn't it help me understand, you're a lawyer. Is it the Supreme Court that helps dictate some of those protocols? Who writes those?
Okay, so there are these rules committees and all this, and the thing is, like, all of our court, well, we have Title 12, which is court procedure, and it talks about different kinds of, processes, cases, and then we have the rules that are in for each court: civil rules, criminal rules, probate, and then we have environmental court. Environmental court rules already have flexibility built into them. They give the judges, they say this is for expedited and summary review while preserving due process. And the problem is, listening to the testimony of the judges, oh, if you come in, we will give you a hearing. If you ask for it in 30 days, we can accommodate you. The problem is the other side. And then the other side has to agree to that, and it doesn't happen.
So who writes those rules, Brooke? Who writes those rules for the environmental court?
So it's a big, huge committee thing. And there's, there are committees of rules that are people that they have that position, and once a year, I don't know how often they do it, but they get together and they do stuff. So, but the point is that the tool is already there for the environmental division. It's in the rules that they can limit discovery, but it doesn't happen. That is what we're hearing from all of the lawyers. I agree with them because I've been through that for many, many decades now. And the APA and the executive branch operating quasi-judicially can limit due process, if you want to call it that, can confine. You don't get to ask discovery. Show up and let's hear your case. Or, if it's motion practice, that's more difficult to limit, but you put time limits on, and that's how you make them file their motions earlier on and don't wait to the last minute so that, then they're able to drag it out further and further. Those are the kinds of flexibility that the lawyers are talking about that just do not exist within the court process. And,
How do we
Wait,
put
they-
them in the court process? How do we make the rules no longer flexible, but in fact require certain time horizons and such? We can't, legislators can't do that, right? But somebody
Right.
does. So who is that somebody that writes those rules for the court to follow?
Committees is what Brooke said.
I mean, it's a committee, right?
Yeah.
And here's the thing, Alex, okay? Look, this is our little bailiwick, right? We think this is really, really important from the perspective of the court system. But this is actually the fastest part of the court system. Has each judge in the environmental division, both of them have their own law clerk. That is not the case in the civil or the criminal division. They share law clerks. There already is a significant amount of resources that have been provided to them, and they have guidelines, which the legislature has provided, and they hit the mark about half the time, and they go over the time limits maybe half the time currently based on the latest statistics I have seen. So the question that you pose, so let me just say one last thing. I'll try to make it really quick. So I was planning on doing little like 1 hour Teams meetings on specific issues to get more input because the stakeholders want to continue to be involved in this. That is the very thing that I can have a Teams meeting on. Invite all the lawyers and say, hey, how can we change this? So if you guys want me to isolate those kinds of issues so that I can get better, I don't know all the answers. I'm not on the rules committee, but you know, it's a huge thing that you're asking. There are constitutional dimensions to all of this, right? And so, you know, remember, we're talking about different branches of the government that are checks and balances on each other. They don't get to tell each other what to do. That's the basic premise of, you know, our check and balance system with our 3 arms of government. So I
Right,
will.
but that
I'll
was
give it
where I
some-
was going with
so-
that, was that it was my understanding that the Vermont Supreme Court was responsible for writing rules for Vermont state courts to follow. And the legislature can't do that, right? It's only up to the Vermont Supreme Court to do that. And so what I was asking was, if there are court protocols that we want firmed up or changed, maybe one of our recommendations to the legislature is that they work in hand in glove with the Vermont Supreme Court to make the necessary changes to fix this system, and that it's not just a legislative solution, it's a combination of law from the legislature and changing rules by the Vermont Supreme Court that might get us to where we think we want to go.
So we're almost half hour past, well, 25 minutes almost, but Kirsten, last
Oh,
comment?
Well, Brooke, I was just gonna say in answer to the question of like, does the board think it's a good idea to do separate carve out meetings to do a deeper dive with maybe some more targeted stakeholders on specific topics like that? I think that's a great idea. Absolutely.
Maybe we'll use Alex's question as our first try at that and get some folks together very soon to talk about that.
And make sure that it gets on the webpage for the appeal study.
Oh, sure. For sure. Yeah. I mean, I think there's selected people that we really need to bring their brain in, but absolutely anyone is welcome as well. So, okay.
Okay,
Thank you so
great.
much for all the time. I appreciate it.
Thank you for the summary. So we are proposed executive session, discussion and possible action on appeals and enforcement. We have a docket number 25 ENV 00026. Anybody want to make a motion to enter executive session? Brooke?
Don't have the script in front of me, but let me give it a try. I move that the board enter executive session for the purposes of attorney-client privileged conversations regarding pending appeals, the premature public knowledge of which would place the board or the public at a disadvantage. And that finding be specifically made so that we may enter executive session.
Thank you.
Second.
Thank you, Alex. Any discussion? Okay. All those in favor, please say aye. Aye.
I,
Aye.
That is unanimous. The board will go into executive session and return to this meeting after the executive session has been closed or ended. So see you on the other side. Recording is still in progress. Okay, there is nothing left on the agenda. So I would entertain a motion.
We will move to adjourn.
Thank you, Alex.
Second.
Thank you, Brooke. All those in favor, please say aye. Aye.
Aye.
Unanimous. See you all later.
Thanks, everyone.
Thank you. Thank you,
Thanks,
Maddie.
Maddie.
Thanks, Maddie.